Everyone, my name is Victor Wang, of course. Thank you so much, Tasha, for your warm introduction. And today we are going to be talking about patent law and the business of patents. I'll be focusing on the legal portion, and Russ is an absolute expert on the business portion. So together we have combined forces to give you an onslaught of knowledge and information. And let's see if I may take control of the slides, if you may. Excellent. Okay, I now have control. All right, so let's chat a bit about the basics of patents and understand that you have already completed a first webinar, and I hope you have completed a first webinar on intellectual property at large. But before we start and dive into the patent side, I just wanted to give a little bit of framework on intellectual property. So the question number one, what is intellectual property? Apologies, a little bit of background noise, but intellectual property is the creation of the mind. You are walking down the street, humming a song, you have created something, intellectual property. Or if you're sitting in your chair, thinking about a gadget to solve your problems, that gadget, also creation of the mind, intellectual property. And you as an individual inventor, that would be your creation of your mind. But when it comes to business, it is a little bit different. It's a little bit different for a business, because for business, an intellectual property can be really viewed as the creation that have economic value in use or sale. Because after all, a business, most of the businesses aim to provide a service and goods and to earn a profit. So when it comes to intellectual property for business, it is creation that have economic value. And I generally put all of intellectual property for business into these two buckets. Number one, what it is that you are selling, what it is that you are providing to your customers. And that will be a product, a goods or service. And that tend to be inventions and your creations, the song that you have just written, walking down the street, or the gadgets that you just created, that is a product. And the second type of intellectual property for your business will be your brand. And that has a deep impact, whether people trust your product or not, or people like the makeup of your product. And so these are the different buckets that will place intellectual property. And of course, there are different ways of protecting intellectual property as provided by US laws. And we are today going to be focusing on patents that mostly protect your product, your method that you'll be selling as a business. Of course, copyright for those songs and trade secret for those good recipes, if you will, for success. And that's how your product is protected. And for brands, trademark protection, extremely important. But today, we're going to dive wholeheartedly into patents. And that's the framework that we'd like to provide. And so, question, what is a patent? Now, when I asked myself that question before I went to work as a patent examiner at USPTO, I realized that I have never seen a patent. So let me hopefully show you for the first time ever a patent. And this is an exemplary patent that is near and dear to my heart. It is, the title of it is Squirt Gun, but you might know it more as the Super Soaker. And this is basically my childhood, of course, and I never realized there was a patent on it until I made it my career. And with its history, it has an absolutely wonderful inventor in Mr. Lonnie G. Johnson. owner of more than 100 patents. He has, he basically created my childhood in the Super Soaker, in the Nerf gun. A person that I will bow down to, saying thank you so much. And this is the patent that I will be using as an example when we are going through this patent presentation, right? So this is a patent, and now you have seen, maybe for the first time, a patent. So let's dive into, now we have this example right here on the screen. We will go ahead and discuss what really is a patent. And number one is, what type of patent right is granted to you? What type of right is granted to you once you hold that patent? And that is the right to exclude others from making, using, offering for sale, or selling the invention, which you have created as invention here, in the United States, or importing the invention into the United States. You have a right to exclude. And here we come to the first major concept that I want all inventors, in fact, I truly want everyone to know about what it is that they have once they receive a patent: the right to exclude. And you have the drawing of the Super Soaker here. And let's say, for example, you have obtained a patent for your own Super Soaker, and it is exactly as described in that picture. What you have in your right is now the right to exclude other people, other inventors and companies, from making, selling this Super Soaker as you see here, the picture, its entirety. You can say, hey, look, you can't make that, right? So that's your right to exclude. That's what you have with your patent. But the question now is, well, can you make it? What if you want to manufacture and you want to sell this product? Can you now make the product? Of course, if this was an interactive session, I would ask you to opine on whether you have the right to make. And here, hopefully I can illustrate the differences between these two rights. When you have a patent, you have the right to exclude others, but you do not necessarily have the right to make that product. Why is that? Because other people may have patents too. If you wanted to combine different elements to create your Super Soaker, you might need to make a trigger mechanism, make a water reservoir with a pump attached, right? So these elements that you see here on the right, figure 3, figure 5, these are all different components of the Super Soaker that you might need to manufacture in order to put together and make your product. But what if someone else has a patent on the trigger mechanism? What if someone else has a patent on the water reservoir? Well, then you don't necessarily have the right to make the product that you have invented. So this is a big first concept. I want you to understand that obtaining a patent means you have the right to exclude others, and it is a powerful right, but you also have to make sure that you have the right to make that product. So there are two concepts here. Number one, in order for you to determine whether you can obtain a patent, you conduct what is called a patentability search. In order to determine whether you can make a product, you conduct what is called a clearance search or a freedom to operate. So these two go side by side when it comes to manufacturing or conducting the business of offering a product for sale. So by obtaining a patent is extremely important for you to have I would say, a business market to solidify your market and your product. So that is patents, the right that you have. Now let's talk a little bit about the different types of patents that you may obtain. Number one, utility patent. And this type of patent focuses on protecting a functional, the functional or utilitarian, something with utility type of product. And there are 4 different types of utility, of products that fall under utility patent. That would be method on the left, different types of method of making something. Steps 1 through 5, right? Different methods. 2, a machine, any type of machine, gadgets. 3, articles of manufacture, something that has been manufactured. And 4, the formulas, chemical formulas. Right? So these different types of products fall under a utility patent protection. And the patent term is 20 years from filing date. Second type of patent, something that is very close to my heart, is the design patent. And this protects ornamental design, something that's without a utility/functional workings. So this is a ornamental design. When you look at, for example, the iPhone, right? How it is designed. And the Crocs, no matter what you think about whether it is a beautiful or a subpar product, no matter what you fall on any of these design choices, these are protectable by design patent scheme. And lastly, is something that I always loved. It is a toy starship, otherwise known as the Enterprise. And the design patent term, 15 years from issue date. Third type of patent is a plant patent. And this protects new variety of plants that are asexually reproduced, for example, reproduced by grafting, cutting. I'm not going to talk about too much about this because I concede I'm no expert on plant patents. Right? So this is the patent term, 20 years from filing as well. Same as utility patent. So these are 3 different types of patents that you may bump into throughout your career. Okay. Now we know the different types of patents. We're going to come back to our original Super Soaker patent. And we're going to dissect it, show you what it includes. Number 1, it has a title. And the title for this particular patent is called the squirt gun. Right here, you can see it. Hopefully you can see where my mouse pointer is pointing at. The squirt gun. Of course, this is before the marketing department got to it, right? Super Soaker, definitely a marketable brand, right? So the title right here, and the abstract is right here, circling the abstract. And it is something that describes the patent, the invention. And I would say it is the most English and readable portion of the patent. If you wanted to figure out or understand a little bit about what this patent is all about, read the abstract. A very easy read, in my opinion. The most readable portion. Okay. The patent also has drawings. The drawings are used to illustrate the invention. And you have all these reference numbers on the drawings. And the patent itself will refer to the reference numbers so it could best describe what it is that the patent is protecting. And next is specification. This is where I would say the meat of the description, of the disclosure reside when it comes to a patent. You can read through the specification, and honestly, it reads a little bit like a history book, like an instructions manual. You start out with a background, talk about the invention, or at least the background of invention, what is currently out there, the technology that's currently out there. And there's a brief description of the drawings, and then it gets to be describing the details of the invention. And that is the specification. Usually quite a lot of words going there, many pages. And last, but certainly not least, the claims. The claims is where you can find the legal right that you have for your patent. It's not the specification. The specification really describes your invention, whereas the claims is the specific legal right. They call it the meat and bounds of your legal right. And I just want you to repeat after me. The name of the game is in the claim. It is exceedingly important if you ever assert a patent against a competitor, the claims is where your rights reside. All right. So for example, this is just the first page, the first paragraph of the claims of our Super Soaker. And you can, of course, glance through it. It is a difficult read simply because of the style that a patent is drafted, with which the patent is drafted. So that is, I would say, an art form, drafting and understanding claims. There are, of course, inventors who want to, and engineers who want to tackle drafting a patent application themselves. And I would say that when it comes to drafting the claims, because of the nuances, every word can have a very different meaning than you expect. And there are formalities involved in the claims. I highly do recommend consulting a professional, whether it be a law professor or someone who has had a lot of practical experience, and of course, attorneys. But remember, name of the game is indeed in the claim. So this is a patent. Now that you have seen the basics of it, as it has been dissected, title, drawing, and claims, very important. And I hope that this might be your first patent, but of course, and certainly not your last dealing with patents. And now we know a little bit about the basics of the patent. I want to talk a little bit about how engineers, and this is after all patent law for engineers, I want to talk a little bit about the life of an engineer and their relationship with patents. And here you have a little possible trajectory if you were an engineer in a corporate setting, and you have been hired by a big firm. When I say big firm, I mean big company, Google, IBM, these big companies, where they are looking at you as inventors, as developers, and you will be there to develop IP for them, right? And to provide solutions so they can provide that solutions to customers. So when you're hired by the company, of course, that's the first step. And you as an engineer would likely work in the R&D field. You'll be researching and developing your product, whatever that may be. Once you've come up with a suitable product, often you will submit what is called a invention disclosure form, and you will disclose this invention to your managers. And the manager can decide to file a patent on yours and the company's behalf. And at that point, the managers contact legal, and the legal department will consult sometimes outside counsel. Sometimes you have a lot of attorneys working in-house to draft patent applications. So now the lawyers will consult with you, the inventor, to draft an application. And that continues through a process called the patent prosecution process, whereby the outside counsel or the attorney will try to obtain the patent for you and on behalf of the company and for the company. And hopefully the patent is issued by the USPTO, by the United States Patent and Trademark Office. And everybody's happy. And the engineer will receive a bonus. So that is the general framework of an engineer's relationship with respect to patents. And there are some concepts that I wanted to inform you, some major concepts, so that you understand while you are going through your career. There are some concepts that I just want you to understand so that you are well informed when discussing with your manager, with your company's legal team, or with outside counsel. And number one is there's difference of understanding when it comes to inventorship versus ownership. When you are an inventor, right, at the onset, you have ownership of that invention. And if you see on the left here, Mr. Lonnie Johnson is listed as an inventor, and he owns his patent, he owns his rights. But there is when you are working for a company, frequently you are working for them, and the company is providing you with the resources, with a salary. So in return, what you do is you assign your rights, or you transfer your rights to the company. And if you see the patent on the right side, there's an inventor, Peter, and then there's an assignee right here, and that is to the company. So the inventor, while you, the engineer, is an inventor, the owner of the patent and the rights would be the company. So there is this difference of inventorship versus ownership. That is one concept that I want you to understand. Number two, just giving you a sample, some sample invention disclosure forms, so you're not completely blindsided when you're engineering corporate setting. The left one, we took it from, I screen captured it from Berkeley, and on the right side, it's a screen capture from a sample form from Cooley, a law firm. And so you can see there are many different styles, but essentially you'll need to have a title, have a summary of the invention, talk about the background of the invention, why it is different from existing technology, what is the novelty of this invention. So just fill this information out, and just remember, the more information you give, the better, hopefully the more information the attorney will have, and a better patent will be drafted. That's the hope. So invention disclosure forms. Concept 3, an idea versus invention. And this would be for startup founders and also engineers who may not understand the differences between an idea and invention. An idea is something that is more general. For example, I need a device to essentially effectuate projectile water onto my friends. That is the idea. That is a general idea. Whereas you haven't worked out the specifics yet. You haven't worked out that there needs to be a pump connected to a water reservoir, connected to a trigger. Because the moment you worked out the specifics, now you have an invention. And you may seek patent protection for an invention, but not an idea. Right? So if you have just a general idea, just general thought, that is not yet time for you to submit a patent application. But when you have an invention, a specific idea, that is the time for you to seek patent drafting assistance. So the question to ask is your solution definite and permanent, and the product complete and operative? That is the question. Idea versus invention, okay? Concept 4, and this is something that Russ and I completely agree with, and it's the importance of the provisional and the non-provisional patent application. And there's a lot of intricacies here. A provisional is essentially a bookmark at the USPTO saying, hey, look, I have this invention. I don't have the resources to fully pay an attorney and prosecute just yet. Let me have a bookmark, save my place in line, and within 12 months, I will get back to it. And within 12 months, I'll file a full non-provisional patent application so we can get the show on the road. So the important aspect of a provisional application is it delays examination and attorney's costs. It delays your costs, so you can spend that money elsewhere. Russ will get back. I will get into it in a lot more detail. Okay, so provisional versus non-provisional. Understand that concept. So let's go for a summary. Patents grant you a right to exclude, not necessarily a right to make. Three different types of patents: utility, design, and plant. There are two types of patent applications: provisional, which is a save my place in line bookmark, and non-provisional, the big kahuna. Non-provisional is the one that may become a patent, whereas provisional is just a bookmark, right? It's just save my place in line. Then idea versus invention. If you have an idea, it might not be time for a patent just yet. Invention, excellent. Now we have something. All right. And remember, of course, most important concept, know the claim, know your claims, because that's the name of the game when it comes to patents. All right. And that is my spiel on the legal side of patents. And I hand it over to Russ.
All right, thank you,
There you go.
Victor. That was phenomenal. I want to make sure that I have the ability to advance the slides here, Tasha. So if you could make sure that I am a co-host here. It doesn't look like I can advance them yet.
Russ, if you click on view options on the very top, there might be a way for you to request remote control. And
Okay.
maybe
Here we go. All right, here we are. So that's a tremendous presentation, Victor, on the frameworks and the applications within the patent. Well, I'm going to shift just slightly to talk about how these things apply to you if you decide that you want to pursue your own path outside of the corporate structure. And being engineers, one of the things that you do very well is to see a challenge that exists and to be able to create something physical in many cases, whether you're a mechanical engineer, chemical engineer, you can see how to put these things together. And in that way, you just have that creative mindset and the capability to bring that to something in reality. And it may be something you tinker with around in your garage and find out that this is something that many people would like to use. Usually it starts out in the neighborhood. You've made something to maybe help you do something better in your yard, and your neighbor sees it and says, hey, that's great. Can you make one of those for me? And somebody else, can you make one of those for me? In some cases, that's the way things happen. So homemakers, are a category of people who make really great inventors because they typically are working around the house doing something, and the same thing happens. They come up with something to make their job easier, and before you know it, somebody else sees it and then they want it, and then they begin the process of saying, hey, maybe this can turn into something that can generate some money for me. And that's kind of the start of how these things these seeds are planted. So to put this within the context of what we're talking about, you've created something, you have an invention, and as Victor had mentioned, the difference between an idea and an invention, something that you can put your hands on and come to some outcome. So now let's talk about how you're going to take that into some type of a profit-producing enterprise. And so the first thing is, if you decide that you want to go into business, rule number one is you're in business to make money. When I first heard someone from the stage say that to me, I said, I'm in business to make a difference in the world. I'm in the business to make change. I'm in business to provide solutions to people, and the money will take care of itself. And in the 12 years I've been in business, I've heard that from so many people. But after 2 years of after having heard that from the stage and rejected that wise advice, and I found myself doing tremendous and producing tremendous value for people, and they weren't paying me, I realized that I was not in business. I was a philanthropist. So understand that difference. If you're going to create something and you want to be in business with it, you have to have a mechanism for generating revenue with that product. And if you don't do that, no one will pay you. And as a quick story, this summer, I was asked to do a program for youth to help them write business plans and to do a pitch. And that's my professional expertise. So I did that for 8 weeks. I did it for a friend. I didn't ask them for any money, but it was never offered to me. And that's the way that it happens. If I had wanted money from that, I would have had to ask for it. And it's the same thing if you're going to go down this path. Now, why do I lead with that? Because if you don't generate profit with the product that you're developing, you'll never be able to continue the process. You won't be able to hire people. You won't be able to get the materials. You won't be able to pay the vendors. You just won't be able to continue moving forward. And so when we're talking profit, we're talking your income exceeding your expenses, which is, you know, simple, and everybody knows that. A very simple formula there. So when you start down the path of creating this business around the invention, if you are spending an excessive amount in the very beginning, you're putting yourself way behind the power curve. And as Tasha mentioned, I'm the Vice President of Education for the United Inventors Association. And you wouldn't believe how many people come to us after having spent anywhere from $20,000 to $250,000 on preliminaries without ever having realized what the return on investment will be from this idea. The reason they did that is because they were afraid, and fear was driving their decision. They wanted to protect their idea. And as Victor mentioned, you can't patent an idea. So why would you spend a lot of money trying to protect an idea? And they also wanted to be able to secure that from competition. So these are fear-driven approaches. And what I intend to do today is to show you an approach that is more intentional and purposeful, and that will enable you to spend a small amount of money in the beginning until you get to the point where large amounts of money will be required, because there will be large amounts of money required, but there are ways that we can approach that. So progress is largely linear. So I'm going to show you some sequences. The United Inventors Association has a sequence that we've been using for years. We call it the Inventors Roadmap. I'm going to show you that roadmap. And then after that point, I'll give you some recommendations on how we believe that you should proceed. So the next 3 slides that I'm going to show you are designed to show you the complexity of the path that you're about to go on. And I'm going to try to simplify it by showing you that in these 3 categories, the product development is where you want to make sure that you have a solution to people's problems that they are willing and able to pay for. And these are all of the things that really go into putting together that framework so that you can deliver that information to someone so that they understand it. This is the product development aspect of being in this business. And so these are some of the ideas that you will have to understand. The first one on this slide is the most critical one, and that is understanding the problem or the need and making sure that your invention satisfies that problem or that need for a mass market of people. Because if it's just a small circle, you'll never be able to generate the revenue that you need to move forward. So the objective is to generate some level of inventory that you can then market in a way that you can achieve profitability. The next one here is business development. And of course, once you create this invention, you have it protected, you have all of the things that you need to get it done, people need to pay you for it. So the objective of the business development section is sales, plain and simple sales. And these are some of the things that you will have to consider as you move down the path of sales. There are a variety of different ways that you can sell your product. And if you don't have the ability to manufacture enough to sell in advance, there's still a pre-order strategy that you can follow. As an example, I always use Elon Musk. When he created the Tesla, he sold copies at $100,000 per as pre-orders, and some of those early adopters didn't take possession of that car until 2 years later. So these are some of the strategies that you can think about. Of course, you might do it on a smaller scale, maybe through crowdfunding or some other type of a program where you would maybe sell pre-orders through your website. But there are a variety of different ways that you can raise that money. I tell my clients often in the beginning, you do have to spend money to make money, but what I try to encourage them to do is make money in order to spend money. Investors won't give you money to figure out how to make money, but they will give you money in order to help you make more money. So once you have established that business model, then they will come and they will invest for you to get some of the other things that you need, such as marketing, manufacturing, technical support, engineers, and so forth, in order to help you take that product and move it forward to the mass market. Of course, because what's important to them, return on investment. The third category of components is, of course, the organization development. So once you have successfully launched your product into the market, your company is growing, more and more people are depending upon your solution for their satisfaction, you don't want to let them down. You kind of imagine if the inventor of the iPhone had decided at some point that, hey, you know what, I'm tired. This has been a long journey. It's been fulfilling and fruitful. I made a little bit of money, and now I don't want to go down this path anymore. Of course, you have, Androids on the other side, but the solution to that problem would no longer be there. And if it was something that you had become loyal to, now you have to go back and search for another solution from someone else. So when you start on your path, you want to be able to put something in place that will sustain beyond you. And there are a variety of different ways that you can do that as well. You can license your product. You might create some franchises so that other people are, selling the product, the service that we were offering. And so there are a variety of different ways that you can go down the organization development path. But the whole bottom line here is stability and being able to move forward into the future to continue to serve the people who have become to rely on your product. So those are the components. But when we take a look at the components, we still have to consider sequence, because these are in categories, but the sequence is critically important for your success. So now I'm going to talk a little bit about the sequence. And I'm going to talk about that in 5 stages. The first stage is the conception stage. And what I've done on the left is I've taken those components so that you can see how the components, even though they are in different categories, how they flow in through the particular sequence. So again, I said the most important thing was to identify a problem or a need. You do your research, you identify the advantages, and you notice at the bottom of this is to conduct a trusted focus group. Now, this can be just friends, family, people close to you. They'll give you both sides of the coin in terms of what they believe about the viability of your product. And at this point, it's not so much necessary to have that protection, because you're not really sharing anything yet. You're not sharing your secret sauce. You're not sharing your critical aspects of how you intend to solve the problem. You just want people to acknowledge that this is a real problem and there's a real market for this type of thing. So once you get through that trusted focus group and you say, you know what, there are a lot of people out here who are struggling with this, then you can look forward to moving to the next stage, which is your research and development. And in this stage, now you're really getting into the details of trying to solve this problem, and you want to have some level of protection. And so as Victor mentioned earlier, when he talked about the provisional patent, what we at the United Inventors Association recommend is that at this point, you want to file that initial provisional patent. You want to be able to put patent pending on your invention just to serve as a deterrent, because people will take your idea, and if they have the resources to bring it to market before you can bring it to market, you may actually end up losing the ability to profit from that idea. So when you go to talk to people, if you can say, hey, we have a provisional patent, or you don't say provisional patent, but we have a patent pending, then other people may be deterred from trying to get that thing to market before you. Now, it doesn't mean that they won't. It doesn't mean they won't try, but at least you're putting a little bit of protection in while you continue to work on that project and put it all together. You notice that before the provisional patent, you do the intellectual property search. So you want to make sure, of course, that no one else has already patented what you think was your original idea. I don't know how many times I have come up with something that I thought was original, only to pick up a book somewhere and read it and go, oh, wow, somebody already thought of this. And not only did they think about it, they thought about it 10 years ago. So what you think might be your original idea may not be so original. Still doesn't mean that you can't take it into business. You just have to be different or better rather than being first. But you want to be able to know what's out there and what you're up against. As you notice through the research and development, you get to the bottom of this stage and you see conduct an external focus group. Now, this is not with friends and family and people you know. In fact, it's just the opposite. This is with the people who would be the users of that particular item, who would make the decisions to purchase that item, who are the ones who are willing and able to buy that item. You want to put this now, your solution and your invention in front of those people. Now you want to test functionality and you want to make sure that it works in a way that will solve the problem that it was intended to solve. The next stage is, once you have that done, now you can get into putting in the structure that will allow you to sell. And this is where we get into the corporate identity and putting in place those things that you need to have in place in order to actually sell your product to the community. And we're getting into the marketing, the packaging, your websites, and all those types of things that let people know that you have a product that will solve their problem and will get them to the solution that they're looking for. And now we really get into the commitment, because when we start talking supply chain, now we're really talking a lot of money. Up to this stage, in the first phase, you might have spent maybe $500. By the second phase, you might have spent maybe up to $5,000. Just kind of ballpark figures. It could be a lot more than that. By the third phase, you're really getting into, a little bit more money. But by this phase, you could be talking hundreds of thousands of dollars when you get to this phase, because now you're talking about manufacturing, you're talking about production. And so these things can really get to be incredibly expensive. And so, as I mentioned before, the sequence is important, because if you get to any one of those stages before you get here and decide that your product is not going to generate the return on investment that you hoped it would, you can always stop at that point and cut your losses without having done something catastrophic like mortgaging your house, which, as I mentioned earlier, people have done. Now, in this stage is now, again, you're getting serious about this, and now you're sharing some of the details. People can't produce and develop and manufacture your product if they don't know the details of it. So you really want to get serious at this point about putting in that patent paperwork. Now you're going beyond the provisional patent to the things that Victor pointed out in terms of your design patent, your utility patent. Now you really need to have these protections in place. The good news is, if you have been fairly successful with some of your pre-order strategies or with some of your sales strategies, if you had enough capability to sell something up front, you might even have already generated the amount of money you need to pay these costs. And now the pressure is not quite so much as you're making this level of investment. And so this is where you really get serious about that patent. And then in the final stage, now this is where you're full on, full out, engaged and making it happen for yourself. And in this stage, now we get into some other things where having that patent can now give you the ability to get that return on investment. If you want to have a licensing strategy, you'll need to have that patent protection. If you want to go to a large corporation to sell your patent, if you wanted to do anything with that patent, and many of you have watched Shark Tank, and you've seen where these investors had said, well, I'd love to support you in your product. I'll give you this amount of money. And of course, I would like to have, some rights to your patents and those sorts of things. It's negotiable. You can negotiate it, and this is what you want to have, but you want to be protected as you get down that path. So this is the sequence of things that we're talking about. And again, you'll have these slides, so you'll be able to dig into them a little bit more deeply as you decide that you want to go down this path. So what I want to jump into here a little bit now is, and I'm going to go through this fairly quickly, but again, the purpose of the patent, Victor covered this fairly well, it gives an incentive to share your ideas, because if you didn't have that type of protection, you'd want to keep it under a bushel, and that does no one any good. So you want to have that protection. In terms of business opportunities, I just mentioned licensing, selling the invention to a third party, and suing if somebody infringes on the patent. Unfortunately, as I mentioned, we don't want to be naive when we go into business. And there are some people who go into business and they'll see an invention and they'll try to get a patent on it so that they can then hold people hostage with it. So you have to be aware of that. I'm not saying that to be as much negative as I am to say be aware and just keep your eyes open for those types of things that could happen. Business is great. But there's a dark side to it. Just be aware. The types of patents, we talked about these already, so I'll just kind of skip through that one. Defending the patent. This is something that I want to bring out because many people who go into business get the patent, they spend the money on the patent, and then they think they're safe. They now have protection, but people will follow you. There are people who have companies that are designed as what they call fast followers. So they look at a product, they see whether or not that product is successful in the market, and they create knockoffs. Happens all the time. And so you want to be aware again that that is going to happen. If you think that nobody's going to copy you, you're fooling yourself. They absolutely will. So you have the ability, once you have that patent, to defend it. But it takes money to defend it. And so I want to share a little bit with that. Share a little bit of that with you. Victor mentioned the claim. And in order to make sure that that claim construction is effective, it could have a starting entry of $250,000 and up to defend your patent. So, and then to take it to trial could be $700,000 and up. Now, I say this so you're aware. If your company is not making and generating a lot of money, it may be difficult to meet these costs. So what we recommend is that the first thing you do when you have your invention is sell as many of them as you can. Build up brand loyalty, build up a customer follower, build up a pipeline of people who will continually purchase this product. So you want to have that in the back of your mind as you are going down this path, is that there could be a situation where you may have to address these costs. And in many cases, inventors are not told about them up front. And so you need to be aware. The remedies that you can get when someone infringes upon your patent, if you take this to litigation and win, you can get monetary damages from that. And that could make a huge difference. And I have some stories about situations where that has occurred. Or you can just get them to cease and desist. You know, stop infringing on my patent, stop selling the knockoffs. And then that way, the people who are out there who are purchasing your product can get the real deal, the real quality. And that's what you want, because you created it for that purpose. So those are a couple of the things that would happen if you once you take that idea, take that to trial and win. So the recommendations are, first of all, understand what you're protecting, why and how. As Victor mentioned, you can't protect an idea. You have to protect an invention. You want to protect it because you want to be able to profit from your creativity. And the way you do that is to understand the sequence of patent progress. We recommend you be first to market if you can with this idea and build a brand loyalty, as I just said. Determine how you will achieve the return on your investment dollars. As you patent it, if you understand that, you know what, this is a patent that I want to sell to X company, you just have to have that mindset in terms of how you're going to get that return. Don't make decisions based on fear. We started out with that. Too many people do that. They put themselves behind the power curve from the very beginning, and they never get to bring their product to market because they proceeded in the wrong sequence. And finally, evaluate whether defending is actually worth the opportunity cost. And I'll use Sarah Blakely with Spanx as an example. She said, yeah, there were people who infringed upon her patent, but she decided that it was more important for her to continue forging forward rather than to fight them on it, because fighting them on it would have drained her resources, the ones that she could be using to build the company. And that's a decision that you have to be ready to make. Are you going to defend? Are you going to allow other people to knock off your product? But that's why we have the attorneys. That's why you want to be talking to your CPAs. That's why you want the professional advice. And I do want to give that disclaimer at this moment. What I've been talking about for this entire process is business related. It's not legal, and it's not accounting advice to you. And so protecting an idea, I don't need to belabor this anymore. An idea has no value yet. The design is not finalized. Return on investment is unknown. Competition is unknown. So trying to get a patent to protect an idea is extremely premature. And then some of the concerns, time consuming, maybe it's premature to get it. What is the wisdom of the business decision? And are you getting the patent because it's cool to have, or are you getting the patent because you really want to be able to get something unique out into the community for people to solve their problems and make some money in the process? So just understand why you're doing it. And then the way ahead is, of course, test the idea, get together a prototype, sell, pre-orders or crowdfunding, and then make good use of the provisional patent and or the non-disclosure agreements that can help you protect the idea or the concept until you can get it to the point where it is an invention and you have something that you can actually patent. And that is the end of my portion of the presentation, and we can do some Q&A.
Thanks, Russ. Before we jump into Q&A, we have a special announcement for those in the audience today. So David Pointer is joining us in order to make that announcement. So I'll turn it over to you, David.
Thanks, Tasha. Yeah, once again, amazing presentation by both Russ and Victor. So as Tasha mentioned, we are going to be having another event. I think it's a third webinar in around mid-November, and we're going to be talking about careers and IP. So if you go to law school and you want to pursue this path, there are a lot of different opportunities that you can kind of pursue. And so we're going to discuss that with people that are in different aspects of IP. So it's going to be an exciting next series to continue this series that's been going on today.
Thanks so much, David. And now we only have a few minutes left. So Leandria, if we have, maybe we have time for one question, I think.
Awesome. Awesome presentation, guys. We do have one question in the chat. Is it possible to get free help with the process? For example, can I call up the USPTO to ask my questions?
Hi, absolutely. So when it comes to, the patent process, absolutely complicated, and the short answer is yes. There are inventor hotlines at the USPTO, and they are, quite helpful when it comes to answering what kind of forms do I need, and the logistics of the filing process. And that is the, I guess, the step-by-step guidance for USPTO. But when it comes to drafting the application, there are also assistance. There's also assistance, and in that, patent attorneys would sometimes draft applications pro bono. as long as you, the inventor, fulfill two criteria. One is that you know the basic patent process and you can just watch the videos at USPTO. And two, the more important one is there is a income threshold requirement for pro bono assistance. And I think for this, it's always 3 times, the inventor needs to be making 3 times, less than 3 times the federal poverty threshold. For example, if you are an inventor and you make, I think right now it's about $38,000 a year. And if you're a single person household, that will be the threshold. You need to earn a bit less than that. If you have 2 people threshold, the amount is increased. And of course, you do have to do a little bit of math. But that information on federal poverty, on the specific number, is provided at USPTO as well. And you can look that up. That everything I said makes sense, Russ?
Absolutely. At the United Inventors Association, what we do is refer them to you.
Yes.
We refer them to the USPTO. We refer them to any law firms that we know who do offer pro bono services or any programs that are available where they might be able to get that free help.
Absolutely. And shameless plug, I am the director of the Patent Diversity Project here at Cardozo, and we do refer you to our network of attorneys who draft patent applications pro bono. And we actually help you on a holistic level to see whether, is this the time for you to obtain a patent? And we will connect you with the pro bono attorneys. Yeah, that's our program. But when it comes to business, when it comes to any business questions, you go to Russ.
Yes.
Awesome, awesome. And if Tasha doesn't mind, we have one more question in the chat. It says, my nephew is very creative in coming up with unique beats, pieces of music which can be used in ads and such. How can he patent his digital creations?
Absolutely. I'm going to start and or do you, Russ, would you like to?
Well, let me just say,
Yes.
For business, first you have to see, for us from the business perspective, is a patent the right thing? Would it be more copyright? Would it, which seems to be where it would fall for me. That would be what I would look at is, first of all, make sure that you're using the right mechanism, and then you'll be able to determine which category it fits in.
Yeah, absolutely. And I think when it comes to beats specifically, that will be a copyright, because that is an artistic expression, and that will fall under copyright protection for intellectual property. But if there is a unique process in making the beat, or if there's any type of gadgets or software process, that may fall under patents, but the beats itself would highly likely be copyright.
Awesome, thank you. And that's all the questions we have today.
Wonderful.
I believe Tasha is frozen on the webinar, but if she doesn't mind me saying, thank you guys both for presenting on this very informative topic. I'm sure a lot of people will get some great use out of it. Thank you for taking your time to join us. And I hope everyone joins us for the next series that we have going. Please look out on our social media and for emails on our next webinar series in IP for the people. So if there are no further questions and everyone is okay, I think we can adjourn. Thank you, guys.
Thank you. Thank you for having us.
Of course.